So the bill doesn't, but Florida law has protected media outlets and all individuals since 2000. There's a Florida law called the SLAPP Act, the Strategic Lawsuits Against Public Participation Act, and it's designed, and it's actually just protection for media companies, really, media companies regardless of size, that pretty much protects against frivolous lawsuits designed to shut people up. That's been on the books since 2000, and the bill does not try and propose to do away with that law.
Okay.
So regardless of what the Supreme Court did in policymaking in the 60s with Sullivan, in 2000 we put that into law, like the state did, to protect people from those frivolous lawsuits that people might be concerned about. And that statute's not getting messed with. I would say that's the wrong question, just because that's not where we're at in the United States. So keep in mind, we had the First Amendment in the Constitution for nearly 200 years before Sullivan ever came about. Sullivan didn't create the First Amendment. The First Amendment is sacrosanct. It's a constitutional right. Since Sullivan, we do have things like the SLAPP Act. We also have protections in Florida law against frivolous lawsuits, Florida Statute 57105. We also have a litany of case law other than Sullivan discussing this. Like, we know what the examples are of people suing people just to shut them up, and we have a litany of protections against that. The dynamic really we've transcended that concern. We're never going back to that point. We're at a point now where you have 3 Supreme Court justices at least who've voiced concerns about the unintended consequences of the Supreme Court engaging in policy making with New York Times versus Sullivan, right? So you had Atlantic Hagen in 1991 pointing out specific examples of where meritorious defamation claims were barred and people lost their claims that were meritorious. It was actual defamation. It was actual harm. They lost because of the unintended consequences of New York Times versus Sullivan. So that's the dynamic that we're shifting from. It's not opening the door to non-meritorious claims. It's literally just getting to a posture where fewer meritorious claims get knocked out inappropriately. One, the media has the First Amendment right. Sullivan didn't give it to them, right?
Right.
The media still has a responsibility to at least try to get it right. Prior to Sullivan, defamation claims were brought solely on a negligence standard. The only protection that Sullivan gave to media companies was when media companies are talking about public officials, people in positions like elected or appointed office. They said, well, you don't get to meet that negligence standard to win damages. You have to meet this new kind of recklessness standard on steroids that they defined as actual malice. Actual malice doesn't mean malicious intent. Actual malice means knew or should have known that the information was false. But because of the interpretation of that standard, it's become impossible at this point, to the point where, like in the 80s, I don't think anybody was worried about the chilling effect in the 80s of these defamation lawsuits, but you had an average of 23 defamation claims a year that went to verdict against media companies across the country. Today, we have, I think it's about three a year. So it's a significantly lower amount, despite the fact that we have so many more media companies. Like, the dynamic's not shutting up media companies from talking about legitimate public issues. The dynamic now is media companies, regardless of size, getting to act with impunity without having to fact check anything. I mean, Neil Gorsuch said right now, like, the standard for media companies to avoid liability is just ignorance is bliss. I mean, you're disincentivized from having fact checkers. You're incentivized to have headline writers, and you're incentivized to write more and more salacious things to push that limit, because there's such an imbalance right now in defamation law. The frivolous concern is protected by the SLAPP Act. The only issue, the only scenario that this bill would change is the meritorious defamation, where the media company did not do their due diligence. That's the only time a case would go farther if this bill passes than it would otherwise.
But that being said, is if let's say for instance if we write something you don't like and you hit us with a lawsuit, you're claiming that it's false, libelous, slanderous. You still file the charge, file the case,
Yeah.
the complaint, and we have to prove that it was, and we did our due diligence. Whether you don't know, how does that?
Well, no, the burden's on the plaintiff right now. The burden is fully on the plaintiff. The plaintiff has to, one, identify the false statement of fact, right? If I don't like your opinion, I don't get to sue you. I can try, but that's squarely a frivolous lawsuit that the SLAPP Act protects against.
But that's the thing is, I think the bill could signal to a lot of people that, you know what, I'll just file a lawsuit. And even as you know, as you're an attorney, people file a lawsuit, the other side has to defend it, and by defending it, they have to hire an attorney, spend thousands of dollars to get to the point of saying whether the person drops the case or get to the point where the judge says this is frivolous or not.
Yeah,
and that's kind of where.
But in the
concern.
In the same vein, like I can't control the perception of someone who adamantly believes that the Stop Woke Act last year bans the teaching of Black history in schools. It's just like it's bullshit. But I can't control that perception. If you want to believe that you're entitled to be an idiot, right? It's the same here. Like, my focus is on the actual policy, the underlying policy. Like, I know what would happen if more frivolous defamation lawsuits were brought. They'd get dismissed. If somehow this bill, your concern is that this bill, people are going to, read the misleading headlines and think that this allows for frivolous lawsuits, this allows for people to try and sue companies to shut them up. Like, I can't control that perception. The bill 100% does not do that. Like, that's the thing. So the reality is the bill does not do that. If you file more frivolous lawsuits, you get hit massively with penalties as the plaintiff. Like, we have statutes in Florida right now that penalize plaintiffs and plaintiffs' lawyers for bringing those frivolous lawsuits. And if we did see that pattern, they would just get dinged more and more with 57105 motions where the plaintiff and the lawyer would have to pay your fees for bringing that frivolous lawsuit.
But with that said, I agree with you. But with that said, is that all it takes is for one meeting out, one suit, whether there's a pattern or not. There may not show a pattern from someone filing a frivolous lawsuit, and it may
it's not a pattern. You can like for 57105, I can't point to other frivolous lawsuits you filed. I have to say this one's frivolous. Like but it's very easy in a defamation claim to show that a defamation claim is frivolous, right? Like, if you file a complaint based on a statement of opinion, you're filing a frivolous lawsuit. Yeah, just one second. If you file a complaint, like, based on opinion, you're filing a frivolous lawsuit. If you're filing a complaint based on a true statement, you as the plaintiff should know it's true or not. You're the one you're the one that the statement is being made about. Right? That normally, again, you're the one that knows if it's true or false. If you file a complaint and claim that a statement of fact that is true is defamation, then yeah, absolutely, you should get hit with. You should have to go pay the fees and fines. And again, I'm less concerned about that, just because I'm more focused on getting it right. Like the unintended consequences of people misinterpreting like what a bill does and does not do is not the same as like the actual unintended consequences of what a bill actually does and does not do. The bill does not actually open that door. If people want to test it, like the reason why you're not going to see that wave is even if one person gets one shady lawyer to test it, you're going to immediately see exactly what I just explained, where they're going to have to go pay fines and fees. Like, that's the dynamic. That's why it's just not going to happen. Yeah, but yeah.
How do you prove that? If someone sues you off what an anonymous source says without outing that person?
Well, yeah, without outing that person, you got to be able to point to what primary source you look to try and confirm that, or what you did to try and confirm that anonymous source's claim. What
if your source is the anonymous source? Let's say, for instance, like if you said, "Hob, don't put my name on
if it's
there."
Just if it's just one, if you publish a statement of fact based solely on the claim of one person, regardless if they're anonymous or not, that's can be reckless if it turns out to be defamatory. If the statement the anonymous source gave you, though, is true, you're not going to get sued for it.
But
And
how
if
do you
you
know
are,
it's true though?
well, the plaintiff is the one that has to know it's true or not. Like, if the plaintiff knows the anonymous source said something that is true, and the plaintiff is dumb enough to file that lawsuit, the plaintiff is going to have to pay your attorney's fees and costs for defending yourself for publishing a true statement.
But if the plaintiff says, well, it's my word against his, and they still file it because that's his case, it's my word against his, regardless of who the source is, let's say the source is a credible source, that it's again, it's he said, she said.
The burden of proof is on the plaintiff to prove that it's a false statement. That's not a burden that the defendant has to meet. Now, if the defendant wants to use truth as a defense, obviously the defendant has to show that it's true.
Right.
But
possibly out the source.
But even if the defendant never uses truth as a defense, the plaintiff has to prove that it's false.
So you're saying they wouldn't have to divulge, the defendant wouldn't have to divulge their source.
They wouldn't, in two circumstances. If the defendant looked to primary sources or other sources, other individuals, to try and confirm what that anonymous source said, then the standard is still malice in that case, and you're not required necessarily to disclose the name of the source. There's nothing in the bill that says that journalists are forced or compelled to disclose the name of an anonymous source. The only circumstance where the disclosure of the anonymous source could be a problem is if the defamatory statement, meaning it is a false statement that harms somebody, if the defamatory statement was published based solely on the word of one anonymous source, and the journalist doesn't disclose that anonymous source's name for them to actually vet out exactly like what happened there, mm-hmm. then the standard goes from recklessness to negligence. You still don't automatically get a win as a plaintiff. The standard just goes to like what a private individual right now would have to prove in that case, instead of what a public figure would have to prove in that case.
But what I say, for example, if I had an anonymous source and I verified it to two more anonymous sources, it's like, where do you go from there?
But you provide the evidence that I called two other people. Now
what's the evidence? My word against? Because what if they want to be on the record? What if?
But your testimony under oath is evidence. Your testimony under oath is evidence. If you use three anonymous sources though, and you're not allowing the plaintiff to actually delve into exactly how they got that information, well then, yeah, your standard should be negligence, because the plaintiff who's suing on, because you got to presume that it is an actually defamatory statement. Like in that scenario, what you have is three anonymous sources coming to a reporter, feeding that reporter false information that harms someone's reputation. The plaintiff absolutely, in that circumstance, if three people like floated a lie about you that hurt your reputation, caused you harm, and that plaintiff doesn't have the opportunity to try and vet that out at all, figure out what happened. Like, it sounds obviously like there was a conspiracy to plant false information, which, by the way, is a crime in Florida. Mm-hmm. It's a misdemeanor. It's been a misdemeanor since the 70s to feed false defamatory information to a newspaper. In that circumstance, then yeah, the standard should be negligence. It shouldn't be recklessness. But again, it's not a automatic like you have to pay, damages in that case. You got to go look then to see if the defamatory statement was like defamation per se, which means like it was such a harmful claim. Like if you claim like a public figure has an STD, and you base that solely on like three anonymous sources, well, that's defamation per se. That's obviously harmful to that person's reputation. They should go and be able to get like punitive damages in that case. But if it's defamation per quote, if like it's three anonymous sources that fed you information saying like, well, this guy's got a history of traffic tickets and speeding violations, well, that's not necessarily defamation per se. Like, you'd have to delve into why that hurt that person's reputation, and that person's still limited to actual damages, the actual financial harm they suffered because somebody published a false statement that they had a bunch of traffic tickets.